Thank you. I don't know what's going on in this room, but obviously something big on the left side of the room, because from my standpoint, I guess the right side of the room from there, but you all over here, a privileged few then, the chosen ones, with not to go disparity too. No, I'm just kidding. We will have our hearing, and then we will work on final action. Committee, just for a housekeeping, I was planning on working this one we're hearing this afternoon, but I'm going to wait, and we'll do it next week with the round of bills we're hearing. Well, I think there's an amendment coming, and so we want to make sure there's proper time to do that and not keep you here. So that works with everybody. Okay. Representative Featherston is in the building. She is testifying on a bill in another committee, so she will be here soon. But let's go ahead and start with the hearing. And so we will open up the hearing on House Bill 2563. And Kyle, if you want to give us a description of the bill.
Thank you, Mr. Chairman, members of the committee. So House Bill 2563 is amending 3 different acts. And so in a way, this bill is sort of 3 separate bills that has already been combined into one. So there might be different provisions where I'm talking about licensees or fees or penalties. And when I'm doing that, it's only applicable to one of those 3 acts. So the bill amends the Kansas Seed Law, the Plant Pest Act, and the Commercial Industrial Hemp Act. New Section 1 would amend the Commercial Industrial Hemp Act to allow the Kansas Department of Agriculture to provide industrial hemp testing services to persons or governmental entities who are not licensed under the Commercial Industrial Hemp Act, including law enforcement agencies, when the department has the capacity to do so. A secretary would establish a fee schedule through rules and regulations for such testing. The fees would be credited to the Laboratory Testing Services Fee Fund. Additionally, the results of such tests shall be made available to the KBI upon request. And then in new Section 2, we're jumping over to the Kansas Seed Law, and that would create labeling and coloring requirements for seeds that have been treated with irritating or poisonous substances that are harmful to humans or other vertebrate animals. The section would also include labeling requirements for seeds that are treated with substances that are not harmful and for seeds that have been treated with an inoculant. And then sections 3 through 11, which are on pages 1 through 15, make various additional amendments to the Kansas Seed Law. Under current law, it is unlawful to sell or offer to sell agricultural seed that contains noxious weed seeds or certain amounts of restricted weed seed. Under current law, the definitions of noxious weed seed and restricted weed seed list individual plant species. Under the bill, noxious weed seed, and you can find that term on page 3 of the bill, line 10, would mean the seed of any species of plant declared to be a noxious weed by the Secretary through rules and regulations. Restricted weed seed would be amended to mean seeds that are objectionable but controllable and designated as restricted weed seeds pursuant to rules and regulations adopted by the Secretary in consultation with industry organizations and programs that are within the College of Agriculture of Kansas State University. Additionally, a new definition would be added for prohibited weed seed, which would be seeds or bulblets of species that are highly destructive and difficult to control as designated through the Secretary, through rules and regulations, again in consultation with that same list of stakeholders that I just previously mentioned. The terms noxious weed seed, restricted weed seed, and prohibited weed seed would all fall under the umbrella term weed seed, and that's moving along, Section 4 on page 7, line 31, amends the labeling requirements for agricultural seeds. Section 5, which is on page 9, line 43, amends the Act's current list of unlawful actions. Section 6, which is on page 12, line 39, would amend provisions relating to wholesaler and retailer business registrations, including authorizing the secretary to revoke, suspend, modify, or refuse to renew any such registration under certain circumstances. Section 7, page 13, line 14, would amend the penalties for violating the seed law, including to authorize the secretary to assess a civil fine of not more than $1,000 per violation. Such fines would be credited to the state general fund. Sections 8 through 11, which you can find on pages 14 through 15, make various technical updates to the seed law. Sections 12 through 14, which are on pages 15 through 19, make various amendments to the Plant Pest Act that relate to live plant dealers. A live plant dealer is someone whose business includes growing live plants for sale or distribution, buying or obtaining live plants for reselling or reshipping within Kansas, or planting, transplanting, or moving live plants within the state to plant for other people. Under current law, live plant dealers are required to be licensed, but there is an exception for people who do not import or export plants into or from the state and have an annual gross receipt of less than $10,000 from their business. Under the bill, on page 18, line 29, such exemption would be removed and replaced with a reduced fee not to exceed $50 that would apply to live plant dealers who do not export live plants from the state, have annual gross receipts under $5,000, and have only one location other than a temporary location. Additionally, any person who conducts business as a special event live plant dealer would not be required to obtain a license, but would be required to register with the secretary. You can find that on page 19, line 1. A special event live plant dealer would be defined as a person who conducts business for 5 or fewer days in a calendar year as a nonprofit, charitable, educational, or religious organization, or gives live plants as a premium or for advertising purposes without selling live plants as part of such person's business. That's back on page 17, line 27, that definition. And then we're jumping to the third act that's being amended by this bill. Sections 15 through 18, that's pages 19 through 26, amend the Commercial Industrial Hemp Act, just like new Section 1 did. Section 15 would broaden the definition of state educational institution. Under KSA 23908, such institutions are allowed to use hemp products for research purposes. Section 16, which is on page 20, line 36, would strike language concerning the now defunct research program. And that program was implemented back in 2014 under the Farm Bill. So that language would be stricken, and it would allow the secretary to establish an advisory board through rules and regulations. Additionally, language requiring fingerprinting and criminal record history checks for persons licensed under the research program would be repurposed to apply to individuals employed or seeking employment with the Department of Agriculture who oversee or regulate industrial hemp. And that's on page 22, line 9. And I had noticed that there are some leftover references to licensees in that language that we are repurposing. So I think a technical amendment may be needed at some point to clean that up. And then sections 17 and 18 just make additional technical changes. House Bill 2563 would become effective upon publication in the statute book. I'd be happy to take any preliminary questions.
Questions for Kyle? Representative Minix?
Thank you, Kyle. I started getting emails from people that were concerned about the KBI being involved in fingerprinting people on this third act. it has only to do with basically a background check on those individuals. Is that correct?
Correct. Fingerprinting and a criminal history record check.
That's the only reason that the KBI is utilized, because they're the best state agency to be qualified to do that, correct?
They were likely included because of their expertise in the area, yes.
Thank you.
Other questions? Representative Murphy.
Yes, thank you, Mr. Chair. And that is just for people who are working for the department, right? And it's not for people who are raising it. That's just for people who are working in the department, as I understand it.
Well, so this new change would be applicable for employees and prospective employees of the department. There are other provisions in the current act that aren't a part of this bill that cover growers and employees of processors and those who are disposing of the industrial hemp. So those individuals are required to be fingerprinted and get those same background
That
checks.
remains the way that it was then. Okay, yeah.
Representative Carlin.
Okay, thank you, Mr. Chair. I'm working without a bill in my hand, and so I was trying to listen, but the change then is what I need to understand, because previously, the only people that were fingerprinted was the producers, the people who had manufacturing of hemp products. Is that correct? Anyway, so who now has to be fingerprinted? I understand why it would be the KBI, I think, but who has to be fingerprinted in this bill?
So when industrial hemp language was first put into Kansas law, it was because of that 2014 Farm Bill, and that only authorized research into industrial hemp. And so this language was originally just for that research program, and for people participating in it, they would have to get fingerprinted and get the background checks. And then we had a stage for a few years where there was both the Commercial Industrial Hemp Act that was in effect from the newer Farm Bill in 2018, along with that existing research program. And so we had the growers and the people who were processing the hemp and the individuals underneath the research program who were all under KDA's regulation. So now we are phasing out all of these research provisions because that program has lapsed, essentially. That was built into the 2018 Farm Bill. So this is cleanup, essentially, just getting rid of all those research provisions because they're not being utilized anymore. And so just dealing with the Commercial Industrial Hemp Act, and the growers, processors, and those who are disposing of the product. I could look and get an exact list of everyone who is subject to the fingerprinting and background checks, but I know it does include the employees of the processors, I believe, and those who are disposing of the product.
I think that takes care of my question,
Okay.
if everybody else isn't totally confused by it. Thank you, Mr. Chair.
Thank you, Representative Fairchild.
Thank you, Mr. Chairman. I was just wondering if you could explain a little bit more on page 4, line 40. It says seizure is a legal process including an order issued by a court of competent jurisdiction that allows the secretary to take possession of a definite amount of agricultural seed and undertake or order the disposition of the seed as the court may direct. What exactly is the purpose of that section?
I would need to do a quick search to see how the term is utilized. I don't remember quite off the top of my head. I assume it's in regards to restricted weed seed and things of the like that are unlawful underneath the act that might be discovered through an inspection by the secretary's designee.
Other questions for Kyle? No, thank you. If we need you, we'll know where to find you. Up here. All right, let's continue on with proponents. First, Jeff Vogel, Program Manager for Plant Protection and Weed Control for the Department of Agriculture. Thanks for coming. Welcome to committee.
Good afternoon, Mr. Chairman and members of the committee. I am Jeff Vogel, and I serve as Plant Protection and Weed Control Program Manager for the Kansas Department of Agriculture. And thank you for the opportunity to provide supporting testimony for House Bill 2563. Also in attendance, I have several members of my staff to help. Scott Marsh, State and Weed Specialist, Jennifer Smith, Area Plant Protection Supervisor, and Jason Teal, Industrial Hemp Specialist. The Plant Protection and Weed Control Program has a diverse set of responsibilities. Amongst others include protecting the state's natural and cultivated plants for the introduction and outbreak of plant pests, provide consumer protection by ensuring seed offered for sale meets labeled guarantees, and ensure industrial hemp grown in the state meets the requirements of the Commercial Industrial Hemp Act. House Bill 2563, as Kyle mentioned, updates 3 of the acts this program administrates. On these changes, we consulted with many different stakeholder groups, trying to get kind of a consensus on these changes that help modernize the Act. In addition, the Kansas Grain and Feed Association, the Cooperative Council, Kansas Seed Industry Association, KNLA, the Kansas Nursery and Landscape Association, and the Industrial Hemp Advisory Board. Looking at this, the first act that's being revised and to modernize language and to meet today's practices is the Seed Act, parts of which have not been amended and changed in decades. So I do want to point out just a couple important things, not to revisit what Kyle shared, but creating a new section specifically giving details on how seed that is treated is labeled will provide further protections to consumers or farmers who are handling treated seed. We added oil, food plot, and cover crops to the definition of agricultural seed to extend label requirements to those farmers that use those crops. In addition, we referenced the Noxious Weed Act as the noxious weeds defined in the Seed Act by reference. This is important because it uses the term noxious. Not only is the term noxious is used the same way in both acts. We're not meaning a different set of species. If it's defined as noxious in the Noxious Weed Act, it is a noxious weed seed in the Seed Act too. With that, we created a new category called prohibited weed seed. If there are additional species that need to be listed, need to be zero tolerance in a seed mix, those would be listed as prohibited. And finally, those class of restricted weed seeds would be established, and both restricted and prohibited would be established in rule and regulation to help streamline the process of listing those species. Our intent right now is to keep the list the same, but we would just go the process of doing that in addition to consulting with those stakeholders listed in the bill. Furthermore, to protect consumers from abuse of the law, this bill updates and adds a civil penalty section and a suspension and revocation of license authority to bring it up with other standards that in other acts that KDA administrates. There are also many other changes that clarify language and make it easier to understand that I won't mention right now. Second, proposed amendments to Plant Pest and Agriculture Commodities Certification Act would serve to modernize the existing license structure. There is an attachment with our submitted written testimony that helps explain these changes, what currently is law and what it would look like upon passage of this bill. The current law requires all live plant dealers, actually all locations of live plant dealers, to be licensed except those that have gross receipts under $10,000 and do not import or export plants. Exempt dealers, though, are otherwise subject to the same requirements as licensed live plant dealers and incur the same cost to the agency with the exempt processing and inspections. Furthermore, the use of the term exempt creates confusion amongst dealers and consumers. So, as was mentioned earlier, this replaces exempt with a reduced fee license and a special event live plant dealer license at no cost. In addition to those issues, the current law also requires all locations must be licensed, causing frustration with those who sell plants at farmers markets and other similar festivals. Under House Bill 2563, the language is updated in creating a term called temporary locations, which allows live plant dealers, as long as they're licensed at a primary location, to not have to license those temporary sale locations. Finally, it establishes a late fee for those who are late to renew their license. Oftentimes, live plant dealers are continuing operations throughout the winter. And so this would establish a late fee to help recoup the costs for the department when we're trying to get them licensed. It's $25 after January 31st, which is the expiration date, and then $50 after March 1st. And hopefully that would encourage them to renew on time. Finally, fee updates were made to the Plant Pest Act. The department conducted a fee analysis and looked at our licensing revenue versus the cost it takes for us to conduct verification of these live plant dealers. And with those fee adjustments that are being made in this bill, it will cover the cost of the verification inspections that we conduct on an annual basis for live plant dealers. Furthermore, the requested inspection cost is being amended, or at least being proposed to be amended, from $30 to $45. And this will cover the average cost of a KDA, the KDA cost of an inspector going out in the field and conducting requested inspections. So that's different. In these cases, a commodity is being requested to be certified so that they can export, and then those individuals will be responsible for paying this inspection charge. Both of these together will help and eliminate the year-to-year deficit we do find or do have in the plant protection fee fund at this current time. Finally, proposed changes to the Commercial Industrial Hemp Act will provide KDA discretionary authority to conduct laboratory testing for hemp. This was done, and this language was put together in consultation with KBI, and like I said, it's merely discretionary that allows our KDA laboratories to conduct hemp testing for fee when it is requested. Since the Commercial Industrial Hemp Program has been implemented and under the 2018 Farm Bill, the majority of the research section is unneeded, and so that's being proposed to be revoked. And so that we are also wanting to make the Industrial Hemp Advisory Board part of the permanent commercial program going forward. In closing, House Bill 2563 will update the Kansas Seed Act, Plant Pest Act, and the Commercial Industrial Hemp Act with modern practices and terminology to ensure that KDA can adequately carry out our statutory duties assigned to the agency and provide the necessary funding for a sustainable budget in the future. I'm happy to stand for questions at the appropriate time.
All right, thank you, Mr. Vogel. Questions? So I guess, I mean, it's somewhat a simple bill. It's a lot of cleanup bill, but so those that are live plant dealers now are getting an increase in their fee, correct?
Yes, the bill changes the fee from $80 to $100 per location for the full license.
And if you're temporary, that fee goes away, and you don't have to be registered, right?
That's correct. So if you were at a farmer's market, as long as you had your greenhouse where you were growing the plants were licensed, you would not have to license those locations like it is currently under the Plant Pest Act.
And then reducing the fee for 371 for the live plant dealer locations. So, and again, I'm looking at the chart. Mm-hmm. And so, I guess I'm looking at some of these that are exempted now will not be.
That's correct.
That's correct, right?
That we believe, and then this is an estimate based on what we understand with the industry right now. We believe there will be approximately, we're estimating 50 that will change from an exempt licensed live plant dealer currently to a fully licensed live plant dealer.
And so, and again, even though I read it, I want to make sure, I guess, have it verbally that all these groups that you worked with, this was the, do I say compromise, or does everybody agree that in order for you to do your job, these had to be increased?
Yes, our understanding, talking with the industry, is they support the work we do conducting the inspections, and I believe that's why they,
Any other questions? Seeing none, thank you.
thank you.
We have written testimony for proponent from Shahira Stafford with the Co-op Council. So you'll find that in your packet as well, or online, in your email. Opponent, Nick Reinecker, and is he on online? Mr. Reinecker, thanks for joining us, so welcome to committee.
Thank you, Mr. Chairman and members of the committee, for allowing me to speak today. Can you hear me okay, sir?
Yes.
Very well. I am an opponent to House Bill 2563, and I put down here 10 reasons why before I get into a little explanation. Number one, page 2, line 20 through 26, changing the definition of agricultural seed. Says it means the seed of grass, legumes, forage cereals, and fiber crops. And then it also takes any cannabis sativa crop authorized by state law. And then it also takes out the definition of horticulture seeds that are generally classified as vegetable, fruit, flower, tree, or shrub, and grown for personal use or commercial sale. I would argue that cannabis sativa should not be singled out like that and should be put into the tree or shrub arena and allowed for personal use, whether or not there is a commercial sale. Page 3, lines 31 through page 4, line 31 talks about the prohibited and restricted seed definition. Basically, a lot of this, if you see my testimony about the DEA in 2001 and how they decided to change the definition of cannabis and add, like separating out hemp and calling the other marijuana. In that article that I provided for you from the DEA in 2001, says DEA Administrator Asa Hutchinson stated that many Americans do not know that hemp and marijuana are both parts of the same plant, and that hemp cannot be produced without producing marijuana. So I'm wondering, I'm concerned about how we're going to say prohibited seed versus restricted seed, and just, dividing and conquering this and taking the individual freedoms out and inserting government control and things like that. Number 3, page 4. Lines 41, including the seizure definition. Sorry, I thought I lost audio there. Seizure involved there. I was wondering if there are other legal processes that would allow this to happen. It was kind of muddied. I didn't really understand. So seizure means a legal process including an order. So I thought that needed to be clarified as well. Page 6, lines 36 through 38. Again, eliminating the definition of horticultural seeds. It just seems like that when the government doesn't want the individual to have access to something, it devises ways to divide it and make it illegal or prohibited or highly regulated or whatever. Moving on, page 7, eliminating lines 14 through 17, eliminating cannabis as a cover crop. It's not really feasible or whatever to have cannabis as a cover crop. But again, just that separating out cannabis and making it a star when it comes to agriculture or plants or whatever. Page 7, lines 21 through 23, involving feminized seeds. And I think this is where some of the issues happen, because with feminine seeds, you get some more opportunity for the health benefits, not necessarily the industrial applications, but also the higher Delta-9 THC content after it ages for such a long time, like a good wine or a good cheese that we've been talking about for the last 10 years trying to, well, for my interest as an individual, have freedom with, and for the government's interest, have control over. Page 13, lines 19 through 67. Involving the penalties and the money that's involved with that, and just allowing the secretary to make the rules and regs overburdensome, in my opinion. Page 15, lines 21 through 39 is section 10. Oh, that's more of the allowing the department or the secretary to do rules and regs, somewhat abdicating what I believe your job would be in protecting the defense of liberty and all that good stuff. And then specifically here, page 15, line 34, striking the words "after public hearing." Now, does that mean that there's not going to be a public hearing when these rules and regs are made, or what's the deal there? Because I would like at least an opportunity to address my concerns through a public hearing process. Number 9, any language prohibiting certain individuals. There are people out there that have skills that can put a plant in the ground, feed it and water it, and make it grow. And I don't think that we should be, saying that because you have this skill, you might, do something nefarious. I think we should allow people with the skill to grow plants to do that, whether it's commercially or especially for personal use. And then the origin, I read the seed law and I thought this was new language, but it's not. There's a declaration apparently that if you don't know the origin of where you get the seed from, you can just declare, I don't know where it came from. Well, let me tell you, the seeds don't come from Monsanto. They don't come from whatever or company or this, that, or whatever. They come from the supreme being, whoever created us, if you believe in that thing. And so, which, kind of enhances my belief that we should have access to those things. Mr. Chairman, I've been an EMT, a firefighter, a police officer. I've run a restaurant for the last 14 years. I've been coming up to the legislature for the last 10, expressing my belief that cannabis in any form or whatever should not be on the Controlled Substances Act, regardless of a repugnant federal prohibition against this plant. I won't belabor the point. I respect the process. I respect the committee. I respect each and every one of you and a body collectively. And so I will hesitate any more commentary and just say that I am against overregulation. I thought these were things that met the majority of the Kansas legislature's philosophy when it comes to political action, if you will, and policy making. So I hope that you do the state of Kansas individuals the duty that I believe you should do and eliminate cannabis from the Controlled Substances Act. And those are the concerns that I have with this bill specifically. And I thank you so much for your time and allowing me to speak today. And I will stand for any questions.
Very good. Questions, Mr. Reniker? All right, Nick, thanks. Stand by. All right, I do apologize. I go back. I kind of skipped over and asked for, are there any other proponents here? He was an opponent, yes. And I apologize for that. So are there other opponents here online? Not seeing any or hearing any. Let's go ahead and continue. We'll now go to neutral. And Randy Stuckey from the Kansas Ag Retailers. Stuckey, thanks for coming to committee.
Well, thank you, Mr. Chairman, members of the committee. Randy Stuckey today for Kansas Agribusiness Retailers Association. And I do serve as general counsel for the association. We appear neutral on the bill before you today, House Bill 2563. And we appear neutral with a proposed amendment that I think might be able to get us in line and come on board as a proponent. I don't want to take too much of your time today as a neutral conferee. I do want to say thank you to the agency for reaching out to industry broadly, but certainly our association I think back in August or July of last year. This was a large undertaking, clearly, as you can see by the length of the bill, even though it's three different sections. 15 pages of this would be the Kansas seed law, and that's where we're going to turn our attention today on our comments. The agency rolled out an iteration of their draft. We responded, and this went back and forth 4, 5, 6 different times over many months. So a great deal of work has gone into this work product before you today, and we just want to say thank you to the agency for involving industry in those conversations. But we've come a long way in what's before you today. Some of those changes we want to point out that we really do think are very good improvements to this 100-year-old body of law, the Kansas seed law. Now, what we've been told was one of the main reasons for opening the act was to allow the agency to have civil penalty authority in the act. They don't have that today. Civil penalty authority under the Administrative Procedures Act is something that's broadly used in most of the acts in the KDA enforces. When you have a new civil penalty authority, it's not always a bad thing. If you don't have it, it doesn't mean you're not regulated. It just means you're regulated in a different way. And if the agency's only enforcement action then is to stop sale or some kind of enforcement action like that, there's also criminal penalty authority if they go after or ask the district attorney to take that action. That's not generally ever used. We would like to see, instead of criminal penalty authority used or a stop sale, then maybe a lesser enforcement action through this civil penalty authority. So you'll see in the bill, I believe it's section 7, that new civil penalty authority. Currently it's $100, low of $100 up to $1,000. That's not an unreasonable request there, or civil penalty request. Secondly, then, is an amendment to the administrative process, allowing for notice and hearing, and then an appeal process through the Kansas Administrative Procedures Act and the KJRA. That's the review beyond that. It's kind of wonky, but it's certainly important to those that are have the enforcement actions taken against them. So that'd be a good improvement. There was some discussion on the definition section. That's a lengthy section. I want to draw your attention to something Mr. Vogel mentioned, and that's, I believe you'll find in section 3 or 4. I believe it's section 4 is the main definition section, where there was some discussion on moving the noxious weed, restricted weed, and prohibited weed seed, restricted weed seed, prohibited weed seed, and then noxious weed seed from the statute. Or currently what you have is a list of those seeds in the statute, which means if you want to amend that at any time, you got to go open up the statute. And we know that's a process. It's a process that we would like to avoid if possible. The same way happened with the noxious weed law 2 or 3 years ago. Same principle, that we're going to take the list from the statute, put it in regulation, and we asked that if that were going to occur, you move this and give it the enforcement authority of the Secretary of Agriculture rather than the legislative body, that there's some industry oversight of that. In the noxious weed law, there was the advisory committee that was set up, that was established for that purpose. Here in the act, you'll see that those actions the Secretary would take in consultation with Kansas State University, our land grant, and also with industry. So with that language in the bill itself, I think we're comfortable with that language, removing those lists of seeds from the statute to the regulations. So I want to draw that to your attention. That's an improvement in the bill with that additional language. And then finally, drawing your attention to section 7 of the bill, which is the civil penalty provision, the purpose behind the bill to begin with. Like I said, the $100 to $1,000 is certainly a reasonable civil penalty fee when you think about the other acts that have civil penalties, the fertilizer and pesticide and what have you. Here, though, there is language in the bill that was concerning to us, and that is the language that says $100 to $1,000 for any violation. That's the civil penalty. But every day could be a continuing violation. Well, if you have a continuing violation, or if it's interpreted to be a continuing violation for 15 days, and they max that out, all of a sudden it's not $1,000, it's $15,000. That's not reasonable. And we brought that to the attention of the agency. We had a similar situation with a different bill last year with KDHE that we included this language. We asked for a maximum civil penalty for a continuing violation. The agency responded and said, well, let's just do away with that language, the continuing violation penalty language, and increase the maximum base penalty from $100 to $3,000. And then so we also asked the agency, if you have this broad $100 to $3,000 for any potential violation of the act, and those are set out in the act, it's in the act as well, the bill, the unlawful acts provision. You know, what we'd like to see is what they do with the pesticide program, and that's have an internal document that they say, well, for these types of violations, you're looking at this potential civil penalty. So that the civil penalty that's assessed would not be arbitrary, it would be reasonable and consistent. And they've agreed to work with industry on creating that kind of a document as well. Mr. Chairman, with those comments, then I want to draw you to the back page. I always try to keep my written testimony to one page, if possible. We did have a second. For me, it's a back page. Then that's going to be the proposed amendment that I just discussed, where it would strike then, or the intent would be to allow for a civil penalty from $100 up to a $3,000 violation per violation. And then in the case of a continuing violation, each day such violation continues shall not be deemed a separate violation for the purpose of assessing a new civil penalty. That's the proposed language that I think would get us to where we agreed with KDA on that. And when the body goes to work the bill, we would ask that that proposed amendment be taken into consideration and adopted before the bill goes forward. So, Mr. Chairman, that was a lot and a little bit of time, I think, so I'd certainly stand for any questions and clarification.
Thank you, Randy. Any questions, Mr. Stuckey? Seeing none, thank you.
Thank you very much.
Also neutral, we have Kelly Ripple from Kansas for Hemp. Ms. Ripple, welcome back to committee.
Thank you very much, Chairman Rajas and committee members, for holding today's hearing. I wanted to provide some neutral testimony, and really this is kind of proponent/neutral. For those that don't know, I'm co-founder of Kansas for Hemp, and I'm also the founding president of Planted Association of Kansas. Since its inception in 2018, I've been serving on the Industrial Hemp Advisory Board under the Kansas Department of Agriculture, and it's been an honor, to say the least. I've been very grateful to serve the state in this capacity and see things grow over time, and I commend the Department of Agriculture and this body for helping move things forward. I guess in regards to some earlier statements, I do just want to clarify real quick. Genetically speaking, even though hemp for industrial use and marijuana are cousins, genetically they are not the same. Hemp does not turn into marijuana by going hot or above the 0.3% Delta 9 THC limit. And, state agencies in other states know how to differentiate that and treat cannabis this way. The USDA does agree that this is how we should be doing this. And I allude in my written testimony to a conversation I had with the USDA Hemp Program Director, Bill Richmond, and he had talked about how Kansas program for hemp is one of the most strictest in the U.S., and there is reason for that, and I'm happy to share more information upon request. But I just want to point out that the licenses have changed over time. In 2019, they were 280 licenses. 2021, they went down to 81. And so there are multiple reasons why. There's a long list of learning curves that farmers have had to overcome, as well as weather. Nothing was able to grow very well in 2019, 2020. But we also know, and to some other comments previously stated, we do know that farmers still have the philosophy that hemp should be treated like any other crop. And they would like to see it treated like soybeans and wheat and corn. And so I guess to that point, I was told by the director with the USDA Hemp Program that we could be looking at some more changes regarding the licensing in the 2023 Farm Bill. So we could be here next year looking at some of those provisions. There were a couple things that with this bill specifically that I would like for this committee to address, and they deal with an issue that we've been trying to work with some other folks in the industry and Representative Barker as well. And so there is a bill that just came out of the revisor's office, and this will kind of, we're hoping, fix some of the issues regarding the definition of that 0.3% Delta 9 THC limit. And we would hope that this committee maybe aligns the two sections, section 15, numbers 2 and 4 within this bill of 2563, and align those with that, those provisions set forth. So I stand for any questions, and I appreciate your time.
Thank you, Mr. Ripple. Any questions? Okay. You do? Okay. Representative.
Kyle.
Oh, yeah,
The
went to
question would
Kyle.
be
I'm
for
sorry.
Kyle,
Yes.
because I don't know if I can follow his sections there that he wants to align. Is that possible to do? Would it be removing something? What do you think he meant by that? And we can ask him if you didn't catch that.
I would need to narrow down the specific bill that was being referenced, but I mean, it's always possible to import in different sections of bills. Very doable.
Okay, thank you. Mr. Rimple, would you come back to the microphone and I'll ask you? That was a surprise at the end of your testimony that you wanted to do that. So I want to know what is the purpose for doing it briefly, and what do we put together?
So basically, the provisions that have been changed really just deal with the definition of Delta 9 tetrahydrocannabinol concentration, and so that would read as total percentage of Delta 9 tetrahydrocannabinol, if that makes sense, because it doesn't deal with total free THC, because Delta 9 is its own compound.
So we would put that, align that how? Do you just want that as a definition?
Yes, so I believe it's section 15, number 2. And yes, it would say, you know, Delta 9 tetrahydrocannabinol concentration means total percentage of Delta 9 tetrahydrocannabinol.
Okay. All right, thank you. I want to be sure we got that clear. Did you get that, Kyle? Or if you didn't, ask him again. Thank you, Mr. Chair.
You ready? Hang on, Kelly. You want to do some more research right quick? Okay.
Yeah, okay, thank you.
Representative Smith?
Thank you, Mr. Chair. Mr. Rimple, can you tell us then on that what impact it would have? Are you aware of any impact it would have on Delta 8 tetrahydrocannabinol?
So because of the fact that Delta 8 is not considered a controlled substance by the DEA,
Arguable.
it's not arguable. There was a DEA letter that came out, and I'm happy to share that with you.
Have you seen the AG's opinion on that?
I have.
Kansas AG.
Yes, I have seen the AG's opinion on that.
So it is arguable.
It's not. It's not, and the reason is because
We'll leave it at that. So you don't know of any impact that would have on Delta 8? Then?
I don't agree with the characterization that you have stated.
Of?
That Delta 8 is a controlled substance.
Okay, but besides that fact, that your testimony on Delta 9, you're not aware of how it would have any impact on Delta 8?
Since it is different from Delta 8, it would not.
Thank you, Mr. Chair.
Other questions? Seeing none, thanks for being here. Appreciate it. Anybody else neutral? Seeing none, I will close the hearing on House Bill 2563. Committee, we will work this bill next Wednesday. Okay, thanks all for that. Okay, let's quickly, we have 2 bills to work on for final action. And so with that, Kyle, are you ready? Okay. Just a quick explanation again to remind us, House Bill 2559.
Thank you, Mr. Chairman. House Bill 2559 would create the Kansas Cotton Boll Weevil Program. It also create a board of directors for that program. Who they would be able to assess, levy an assessment upon Kansas-produced cotton up to an amount not to exceed $2. That assessment will be collected when cotton is deposited at the gin, and then the gin would remit it to the board on behalf of the grower. With that, I'd be happy to take any questions.
Any questions for Kyle on this? Seeing none, committee, what is your pleasure on House Bill 2559? Representative Shue.
Thank you, Mr. Chair. I'll move that we pass out House Bill, whatever this is, favorable, 2559, favorable for passage.
Seconded by Smith. Any more discussion? Seeing none, all those in favor signify, oh, I'm sorry, Representative Jacobs.
Thank you, Mr. Chair, and I don't have an amendment, but I have an opinion. Would it be all right for the committee if we make these fees voluntary instead of mandatory?
I think the reason why that they are, in a sense, mandatory, those that are producing the cotton, is that you have a comment, Representative Orr?
I would make a comment. It is optional right now, and that's the whole purpose of this bill, is to make it mandatory. And if it's not needed, the way I understood the bill, they're not going to assess a fee. Okay. So I like that idea. Thank you, Mr. Chair.
Sure, Representative Jacobs.
If I may, thank you, Mr. Chair. So if there's the harvest and we're selling the bales, there's no, if the fee is not needed, or then they're not going to collect that $2 per bale.
I believe I understand. I believe that is correct. And if that level gets high enough, or depending on, that's the way I understand it, correct? Representative Orr.
Chair, on my comment, what I understood is they're now presently charging 50 cents a bale. And if they need more later, they're going to up it, but they intend to leave it at 50 cents a bale. And if, in fact, they don't need that later, they perhaps would reduce that.
Okay, thank you for the clarification.
Yeah, and I apologize, the $2 is the max, up to a maximum, so.
Thanks, sir.
Very good. Other discussion? Okay, all those signify, it's been moved in the second, so all those in favor signify by saying aye. Aye. Opposed, same sign. Aye. Oh, hi, Linda, thank you. Representative Featherston. Okay, the House Bill 2559 passes out of committee. I will ask Representative Orr to carry it on the House floor. He accepts. Okay. I guess I didn't even look over there. I assume you did. No. We got one more right quick. Now, House Bill 2560, and this was a bill we heard a week ago Monday. Kyle, got a quick refresher.
Thank you, Mr. Chairman. This bill would extend certain penalties, fees, and maximum amounts of fees under the Department of Agriculture. Most of those fees are set to be reduced July 1, 2023. This would set those dates back to 2028. In addition, the Water Right Transition Assistance Program is set to expire July 1, 2022, and the bill would push back that expiration date to July 1, 2030.
Any questions, comments? Seeing none, committee, what is your preference? Representative Newland.
Thank you, Mr. Chair. I would move that we pass out this bill favorably for passage.
Second. Representative Murphy seconds. All those in favor signify by saying aye. Aye. Opposed, same sign. Motion carried. House Bill 2560 will be recommended favorably out of committee, and Representative Fairchild will be the carrier of that bill if it goes to the floor. So anything else for the good of the cause? Representative Jacobs, you may be next. So, all right. Any other thing for the good of the cause? Just quickly, committee, no meeting tomorrow. But next week, we will have a pretty busy week. We have a hearing that will probably take the whole time on Monday, House Bill 2531, on that, the right-of-way bill. Tuesday, House Bill 2553, the meat analog bill, that will probably take all day as well. Wednesday, the plan is to work this bill and those two bills. And then we've moved the hearing on Wednesday to Thursday. We'll hear the two bills dealing with veterinarians in Kansas to make sure that the conferees can be here. So any other questions? By the way, our last, if we need to, we'll probably, these bills that we'll hear next week from today, we may meet quickly on that Monday, the last day we will meet before turnaround and work them. So we'll just kind of play that one by ear. So anything else for the good of the cause? Thank you all for being here. We'll find out what's so good about that side of the room. So have a good weekend, and we will talk with you on Monday. We are adjourned.